It is November 14th, and this is a special called meeting because of the time change from this morning. We changed the time to accommodate those of us that attended the Kentucky Association of Counties conference meeting that concluded this morning at lunch. So I know several of us went up, and I know John Burke, Rebecca Johnson, as well as trying to think if I'm leaving anybody else out. JR came by as well and attended. So it was a good conference. But with that said, if we could start our meeting, I'd ask you all to join me in the Pledge of Allegiance. Let's pledge. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all. Ms. Hamilton, will you call the roll, please?
Mr. Hostetler.
Present.
Mr. Jones.
Here.
Mr. Wallace.
Here.
Mr. Corman.
Present.
Mr. Ellison.
Here.
Mr. Pratt.
Here.
Mr. Livingston. Mr. Culbertson.
Here.
Judge Covington.
Present. With that said, we can say that we have a quorum and we can conduct business. With that said, our first item of consideration are the minutes from our previous meeting. Any questions regarding those minutes as presented? Motion from Kelly Corman.
Second.
A second from Rob Jones. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Next, bills and hand checks as presented. Any questions or comments related to those? Motion from Rick Hostetler, second from Ryan Pratt. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Item number 6, let the record reflect that clerk fees in the amount of $196,101.23 were submitted by the office of Rebecca Johnson. And then let the record reflect that sheriff fees in the amount of $52,160.32 were submitted on behalf of Sheriff Jeremy Nettles. Any questions or comments there? Number 7, Resolution 2517, County City Projects. We have talked about this a couple of times, about the desire to move forward. We talked about it last week as well at our meeting, our workshop last Friday. And Cam, could I ask you to read the resolution?
Scott County Fiscal Court, Resolution number 25-17, a resolution of the Scott County Fiscal Court committing to fund the design phases of 2 quality of life projects for Georgetown Scott County Parks and Recreation. Whereas the Interlocal Cooperation Act, KRS 65210 and KRS 65300, permits public agencies to enter into interlocal agreements in the interest of cooperatively sharing resources and providing services and or facilities for their mutual benefit. And whereas Georgetown Scott County Parks and Recreation is a public agency that is jointly funded and formed by the Georgetown City Council and Scott County Fiscal Court through an interlocal agreement approved by the Kentucky Department for Local Government on March 23rd, 2012. And whereas the Director of Georgetown Scott County Parks and Recreation has proposed 6 quality of life projects for the Georgetown City Council and Scott County Fiscal Court to consider. 1, Cloverleaf at Great Crossing Park. 2, Playground at Brooking Park. 3, Pool Addition at Suffaletta Family Aquatic Center. 4, Tennis Courts at Brooking Park. 5, Full Plan and Renovation at Marshall Park. And 6, Playground at Great Crossing Park. And whereas Projects 4, Tennis Courts at Brooking Park, and 6, Playground at Great Crossing Park are being handled by Scott County Fiscal Court either through direct funding or the Land and Water Conservation Fund, LWCF, grant program. And whereas each legislative body has budgeted $250,000 in their respective fiscal year 2025-2026 budgets to fund the design of certain quality of life projects from this list. And whereas during the quarterly meeting in July 2025, the Georgetown Scott County Interlocal Committee unanimously approved supporting completion of the design phase of Projects 1, the Cloverleaf at Great Crossing Park, And 3, pool addition at Suffletta Family Aquatic Center. And whereas the above referenced interlocal agreement provides all purchases made solely for a city project or for city-owned property shall be governed by the city procurement rules. All purchases which are made solely for a county project or for county-owned property shall be governed by the county procurement rules. All purchases which are for a joint county-city project or for property jointly owned or operated shall be approved complying with the rules of both legislative bodies. And whereas under said interlocal agreement, all capital projects or projects with an expected useful life in excess of 5 years and with a cost in excess of $10,000 shall be the expense of the party that owns the site. And whereas said interlocal agreement subsequently provides that the agreement to share equally in the operations of Georgetown Scott County Parks and Recreation does not preclude the periodic contribution of either government to a special project on the property of either government. And whereas the Georgetown City Council and Scott County Fiscal Court desire to jointly and equally fund the design of Projects 1, Cloverleaf at Great Crossing Park, and 3, pool addition at Suffletta Family Aquatic Center, from the list of quality of life projects proposed by the Georgetown Scott County Parks and Recreation for the benefit of the Georgetown Scott County community. Now therefore be it resolved by the Scott County Fiscal Court, 1, that the Scott County Fiscal Court authorizes the Judge Executive to proceed with the procurement of design services for Quality of Life Project 1, Cloverleaf at Great Crossing Park, provided that any design contract for said project shall be brought to the Scott County Fiscal Court for approval. 2, the Scott County Fiscal Court commits to equally sharing with the Georgetown City Council in the cost of design services for Quality of Life Projects 1, Cloverleaf at Great Crossing Park, and 3, pool addition at Suffletta Family Aquatic Center. This resolution was approved, if you vote so, by a vote of the Scott County Fiscal Court this 14th day of November 2025.
Thank you, Cam. Questions or comments? Would there be a motion?
Just, I guess I'm not understanding it, because I can't find the ordinance on my emails anywhere, but, or the resolution.
Do you have a copy of it?
So is the
You want-
Parks and Rec going to be involved with the Great Crossings Park now?
No, all we're doing is we're agreeing to move forward with, we're going to design, we're going to be in charge of procuring design services for additional baseball, softball, youth fields at Great Crossing Park.
Okay.
The city is going to move forward with procuring design services for the Suffletta pool addition that's, been a topic for a long time. We mentioned in the workshop last year that we might ask Branch Sarah Carroll, everybody seemed to, like they're professional services and they've been providing great services to us. So for me to move forward to ask them to provide a proposed contract for that, for our side. So that's all we're doing. But in that also conversation, we talked about the possibility of looking at citing where an amphitheater could go, because there's been discussion about that. So that's where we're at. But this doesn't, Parks and Rec is not going to, we're not changing anything about involvement at Parks and Rec or anything else right now at Great Crossing Park.
Okay.
But part of that was also the financial part. So if the fields, we did those, they did the pool, if there was a difference, one way or the other.
Yeah.
Say theirs was $1 million more than what we were doing, I don't know, I'm just making a number up, then we would participate with half of that, right?
That's the spirit of it, yes.
Right, okay, I just
Yeah.
double checking. I don't think, Rob, you were here for that one.
No,
I think you were
I
out of
missed that
town.
workshop, but I was trying to find that resolution, but I couldn't find it
Yeah.
on emails anywhere.
But we can hand that down to you.
But, I mean, I just wanted to ask
Yeah.
a question, so
Yeah.
I want to make sure I was clear. Yeah, I'll read it.
All right. Any other questions or comments? Did we have a motion?
Motion for approval.
Chad Wallace, Dwayne Ellison with a second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. That leads us to number 8, ordinance 2503, first reading RV campgrounds. And I've had a request for some public comment here just before the meeting started. And of course, we always want to hear from the public, and so we will honor that request. So I would propose that Cam read the summary, and then we'll take any comment from Holden or any planning staff, and then would entertain any comment from the public, and then the fiscal court could make comment and go from there. Does that sound like a plan?
Yep.
Yes,
All
sir.
right. Thank you.
All right. Scott County Fiscal Court Ordinance Number 25-03, an ordinance amending the Georgetown Scott County zoning ordinance regarding RV campgrounds. Summary. 1. Pursuant to its powers under KRS 67.083K, adopts the recommendations of the Georgetown Scott County Planning Commission following a public hearing on October 8, 2025, for amending the Georgetown Scott County zoning ordinance regarding RV campgrounds. 2. Expands the definition of agricultural use recreational to include an RV campground meeting the requirements of the zoning ordinance. 3. Adds definitions of cabin, lodge, open space, park model RV type, primitive camping site, recreational vehicle campground, and usable open space to the zoning ordinance. 4. Under specific use regulations, adds a new section regulating agricultural recreational uses and procedures in A1R zoning. 5. Under specific use regulations, adds a new section regulating the development of recreational vehicle parks and/or recreational vehicle campgrounds, and containing provisions on applicability, general requirements, including lot layout, landscaping, open space, utilities, roadways, additional standards, and application criteria. 6. Amends conditional uses to include public and private parks and recreational areas, including RV campgrounds, as an accessory use to the principal use on the property. 7. Deletes subsection E of Article 4, Section 4.1 and Section 4.11 permitted uses. 8. Amends agricultural districts A1, A1S, and A1R permitted uses to include in A1R zones RV campgrounds. 9. Provides that if any section, subsection, paragraph, sentence, clause, phrase, or portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. 10. Grants the Planning Commission discretion to make non-substantive revisions as necessary to ensure internal consistency, clarity, and conformity with adopted formatting standards. 11. Provides that all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. 12. Takes effect upon passage and publication. The full text of this ordinance is available for examination at the office of the Scott County Fiscal Court Clerk, 101 East Main Street, Georgetown, Kentucky 40324. Introduced and publicly read for the first time November 14th, 2025.
So thank you, Cam. We've had, a lot of work done on this project, several committee meetings and several planning commission meetings, and also public opportunity for feedback and input as well during that whole process. So I'll call on Holden. Holden, do you have any comments that you'd like to make, or?
Again, I would just like to thank the fiscal court for taking this under consideration. The draft that you have in front of you is the representation of the culmination of all of the public input, the public process, and the Planning Commission's considerations of the proposals that have thus far been made. So I look forward to the action taken by the court.
Thank you for your all's work, Rhett, and Elise as well, and your whole team. Quite a bit of work went in on this, and appreciate the efforts. Now, with that said, I would entertain any public comment. I would ask to try to keep it brief and concise, around 4 minutes, and would be more than willing to allow for that at this time.
Judge, I'm Dick Murphy. I'm here on behalf of the Kentucky Bluegrass Experience Resort. I do have one handout, if I could approach it and just have it passed down
Absolutely.
here.
Yes, sir.
Gladly.
Those were the handout I gave to the Planning Commission on October 1st, but those comments still apply to this ordinance. And I apologize, I was out of town last week when you had some public input, and appreciate this opportunity to do it. I'm not going to go over my handout because I do talk about a number of specific provisions in there, but I would like to talk about the general concept of this. As you know, my client is the owner of the Bluegrass Kentucky Experience Resort. We had applied for a zone change a year ago. We withdrew it. So there's no zone change pending on this, but we do own the land, and we do have a big stake in this ordinance. Our problem is the ordinance itself. As you all know, last year the legislature passed House Bill 443, which specified that plats and development plans are ministerial in nature, and that is that when the Planning Commission reviews those, they have to go through, and if the plan or subdivision plat meets all the requirements checked off, they have to be approved. There's no discretion applied at all. But at the same time, that clarifies that zone changes are discretionary with you all. And this ordinance in particular, it's important because any RV park that ever comes before you in Scott County is going to have a zone change to the A1R zone. So any RV park that ever comes up will have to come before you all. Now, on zone changes, you all have the discretion to look at all the facts, hear all the comments that you have, and make your decision on what's best for the community. The problem with this ordinance is that there's I've counted at least 36 embedded requirements in here, which have become a negative checklist. And that is, you go through one, well, you don't meet one, you're out. If you've met 12 of them, and the 13th you don't meet, you can't do it. If you've done 35 and all those are fine, and the 36th one you don't pass, you're out. And that's not the way to treat zone changes, because zone changes are, by definition, discretionary. You all get to apply your discretion to them. This ordinance takes all the discretion away from you all when you make your decision. We've got no problem with looking at all the factors that are mentioned in this ordinance. For instance, the existence of prime farmland, availability and adequacy of sewage treatment, and the water supply, buffering. One thing that's not mentioned is proximity to an interstate interchange. We think that ought to be considered, because the closer you are to an interstate interchange, the less people have to drive on local roads. But an adequacy of entrance features, impact on tourism, length of stay of guests, and connections to public roads and that sort of thing. We got no problem with those being the things that are considered. And under normal ordinance, that would simply list those factors as things that you all need to look at before you decide whether you grant a zone change or not. But as I said, under this ordinance, it's if it has very specific standards. If you don't meet one, you're gone. You lose your opportunity to do it. And our concern is that what this amounts to is that this ordinance is an ordinance which says that RV parks are allowed, but in reality, it's going to mean that you will never have a new RV park in Scott County, because nobody is going to be able to meet all those conditions. And if that's what you want, we just ask you to be straightforward. Just come out and say, no RV parks. Just say it. But because I don't think anybody's going to be able to meet all these requirements. We run it by our people who have expertise on these items, and all the time we look at it, somebody says, well, you're going to have a problem with this or this or this or whatever. It's going to disqualify you. And they're also saying nobody's going to be able to meet all those requirements. So Anyway, I'm not going to go over each of the little sections on there. I appreciate the time to address you on this, but that's our real concern. We think you ought to do an ordinance that gives you the discretion that you all have as magistrates and fiscal court members on zone changes that come up before you. Thank you very much. Appreciate it. And
Thank you.
We would hope you vote down this ordinance.
Thank you. Would there be any other public comment?
Dick Murphy, Farmer Dick Murphy, I feel.
Yeah.
It's confusing.
I feel compelled to give a slight rebuttal to what Dick Murphy just said. I've heard that concern about there being 36 requirements in this document. That's the third time that I've heard him say that. The reality is, I also can count, and I looked back at the previous ordinance, which apparently there was no problem with. It had 56 requirements in it. So from that standpoint, Holden and others, I think we did an improvement. We actually cut down on some of the requirements. So I like to say, let's not count the requirements, let's make the requirements count. And I think that we've come up with a really good example of an ordinance that is community-based. It had lots of input to it, lots of opportunity for folks to, it's not exactly the way I would do it, but it's darn better than the previous one was, and I'm happy with it. As far as no RV park being able to meet this, I have to take exception to that. There's one up the road about 10 or 15 miles, Whispering Hills would be able to, if they needed to apply again, they could meet this. Now, would it be the same number of sites? I don't know about that, but they could definitely meet the requirements. So, with that said, thank you.
Thank you. That said, if there would be no other public comment, then I would be glad to take any comment or questions from any magistrate.
Judge, in the ordinance that was recommended by Planning and Zoning, there's 4 amendments that I would suggest, and they are highlighted in red, and those were all discussed on Friday of last week. One, I would suggest that we would return on 2.514 and under number 1 to return the language to be prevalent instead of predominant. That is already in the comprehensive plan, and that has been there, I believe, 30 years in that plan, and I just think that would be consistent with what we're already doing. The second amendment would be...
And Chad,
Yeah.
on that topic, do you propose a definition?
Yeah, the definition as well of what prevalent would, kind of the spirit of what the intention would be. I guess that's a legal way to say that, Cam.
And that's listed as, in what was discussed, was for purposes of this section, prevalent means widespread or commonly existing.
Right.
So that's part of your amendment.
Yeah, that's correct.
All right.
And I worked with Cam on coming up with the definition. It's difficult because lawyers can argue both sides of this. The second one would have been the liability insurance. That was Magistrate Livingston's recommendation. That's on page 8, and it creates the insurance part of coverage for operation of the RV campground. Under subsection E there on 8, I believe that has to do with easements. Gerald brought that up, and that was discussed in the last meeting. I think Cam, and if you want to speak to that, that was language that...
Yeah, I mean, it may be kind of boring, but I may read those 2 draft paragraphs.
So won't you go back to number 6?
So, yeah, going back to number 6, what you mentioned with respect to the liability insurance language, this is language that you and I and David, you all had proposed, and this has been drafted as a proposed amendment. Prior to the operation of an approved RV campground, the applicant shall provide to the Georgetown-Scott County Planning Commission proof of pollution liability insurance adequate to protect public health, safety, and the environment from pollution-related incidents, including but not limited to wastewater discharge, chemical spills, and improper waste disposal. All RV campground operators shall obtain and maintain pollution liability insurance coverage from a licensed insurer authorized to operate in the Commonwealth of Kentucky. The minimum coverage amount shall be $1 million per occurrence and $2 million aggregate. Coverage must include, but is not limited to, on-site and off-site pollution incidents, cleanup and remediation costs, bodily injury and property damage resulting from pollution, and legal defense costs. Operators must provide updated proof of insurance annually or upon request by the Georgetown-Scott County Planning Commission. Operators shall not cancel, materially reduce, or fail to renew any such insurance policy without providing at least 30 days prior written notice to the Georgetown-Scott County Planning Commission. Failure to comply with this provision may result in mandatory closure until compliance is achieved. Such pollution liability insurance shall be further reviewed prior to transfer/sale of the property or prior to further development of the property beyond what has been approved. Now, I would just state that that language came from input from Magistrate Livingston and yourself, Mr. Magistrate Wallace, and it was just an offshoot of the discussion at the meeting last Friday. And then your second amendment with respect to the easements, I can read that part.
Yeah.
So your roadways under E on page 8.
RV campground entrances must connect. Oh, do you want me to say what before we move on to that? I think the current draft just had recommended language requiring a sufficient surety. So I think it was expressed last week that you wanted that to be replaced with insurance requirement. And then I guess as just a brief comment before I read this one, we had some discussion from a citizen last week that was very helpful, and he was talking about balancing the property rights of a person that is a holder of an easement versus property rights of the servient property. So that's where this language is coming from. So RV campground entrances must connect to a collector or arterial roads with a pavement width of at least 16 feet within a half mile of the primary entrance per the approved development plan. These connections cannot be made to easements transversing through adjacent properties without written consent of impacted property owners. And now what I'm going to read is the added language. If, as determined by the Georgetown-Scott County Planning Commission, the proposed connection enlarges, intensifies, or otherwise alters the use of the easement in any manner that changes the essential character, purpose, or scope of the easement as originally granted. For purposes of this provision, a change in the essential character or purpose of the easement includes, without limitation, any modification that materially increases the burden on the servient estate, expands the type, frequency, or intensity of the use beyond that reasonably contemplated at the time of the grant, or introduces a substantially different use or purpose than originally intended. All right, so that's that one.
That one's that one.
Go ahead, Chad.
Yeah, the last one would be on page, it go back to the matrix that we have, the chart on page 10. I would suggest that we take low-density developments off 16 to 18-foot wide roads and leave that as accessory use only. What that'll do is that'll allow for people who've got horse people or farmers or have seasonal help. They can come and they can put their RVs there, but it won't allow for an RV park. And it would just take out permitted for low density, but permitted would be on anything from 19 foot or above. You can, if it's just taking out that one, the red X would just not allow RV parks to be developed on 16 to 18 foot wide roads. And my example was Whispering Hills is already on a 19 foot road, and under this ordinance it would be permitted, and so we don't create issues on roads that are not wide enough to handle the traffic.
So under a 16 to 18-foot wide road, only the accessory use would be permitted.
That's correct,
Under a 19-foot, everything except high density would be permitted.
yeah,
And over 20 or greater, all of it's permitted.
yeah. So, Judge, I would submit those 4 edits.
Questions
Or
or
amendments.
comments? Okay. Questions or comments related to those proposed amendments to the body of the
I
document?
think Holden's got a question.
Just to clarify, for the purposes of insurance, was it the intent of the fiscal court to require that insurance for accessory uses as well as the remainder? Or,
I don't think that was the case.
No, that wasn't my intention.
okay.
So that can be,
But wouldn't an accessory use have to have some type of sewer? Like, we haven't said that they don't need a sewer. So if there's cleanup, there's cleanup. Like, there's nothing here that says accessory use does not have to have a sewer.
I'll leave that to the fiscal court to discuss. Thank you.
I mean, like, this says, if you're gonna have, it doesn't say accessory low density, it says if you have one, you must have a sewer. Private or public. And then we're only talking about private sewers, so let's say that.
You're referencing what specifically, like?
Well, this ordinance says if you have an RV park, it doesn't say if you
So
have an accessory use RV park. It says if you have one, you must have a private or public sewer. We said if you have a private sewer, you must have insurance. So are you saying you want this to say that if you have an accessory use, you don't have to have sewage?
so that's worded, I'm sorry, the way that this is worded, the proposed amendment is worded that anybody that has this RV campground would have to have the insurance. I think Holden is saying, do you want that to include accessory use?
Well, I think though, then you'd have to amend more of it, right? Because we say if you have an RV campground, we don't say density, you must have sewer.
Yeah,
You say is don't change.
yeah, well, we talked about that, and I think that generally speaking, I think David referenced this, that most of the time they leave the horse farms or the farms, if they're doing, to go and dump someplace else.
Like, I'm with you, but
Yeah.
that's not what this says.
If it needs
I
to
mean, I wasn't on the planning commission,
Yeah.
I wasn't in all those meetings, I'm just saying, like, this says, even if you have 2 units, you have to have sewage and you have to have insurance.
I don't think that's my intention to require them to have insurance for accessory use.
So the accessory use is limited to 5 or less. And I would propose that accessory use, if not connected to a public sewer system, 5 or less, in my opinion, they can have a dump, like they can do a dump station themselves, or they can have if they have a private sewer, then I don't know, for the accessory use, do we want to require $1 million liability policy?
But what was discussed was that WEDCO, I believe that's a conditional use permit, correct, Holden? And that it's done like that, WEDCO will then monitor that. But you're asking about the insurance piece of it. Is that?
I'm not asking, I'm just,
Yeah.
like, if I read this ordinance, and Holden, you might, if you read this, would you interpret this to say that if I have an accessory use campground, I have to have a sewer of some sort, right? That's what this says.
Currently, yes. That's why I
So then-
brought the question up.
If you have a sewer, then you have to have insurance, is what we've said. I'm not saying we can't change, I'm just telling you what.
Yeah.
I mean, you can, I think the question is, do you want to make an exception for accessory uses in the proposed amendment?
Could we say that
Which you can do.
if someone pursues an accessory use, that then they would fall under WEDCO's, and that's a given already. That they'd have to meet WEDCO's standard for getting the conditional use permit. I mean, throw me a lifeline there, Holden.
I mean, you just want to say, like, this requirement for liability insurance shall not be required for accessory use? Is that what you're trying to say?
and subject to WEDCO's conditional use permit requirements.
So they would be our conditional use permit requirements. We'd place that out there. But the expectation is they would, accessory or otherwise, they need to meet the WEDCO requirements for either on-site treatment or whatever or the method of approach is. Past that, the insurance, WEDCO doesn't require this insurance. That is us requiring it. And so, yes, the question was to bring up whether or not we need that additional liability insurance for essentially a system that meets WEDCO's requirements but is only serving this accessory use. It would be assumed that in going through the conditional use permit process, we would require them to meet the WEDCO standards. It just would not require a zone change.
So just to make sure, clarify, page 7, Ryan, are you talking about Part D where it says utility, Roman numeral 1 there? RV campgrounds must be served by public water.
Well, yeah, I mean, I'm just reading the ordinance.
Right, no, that's what, so if we're gonna do anything, that's where we gotta go to, right?
I think they changed it to predominant, prevalent.
Is that the part you're talking about? I think so. That's,
So that standard would still remain, whether accessory or low, medium, or high density. The question is we require them to have that public or private on-site treatment, and then do we also require the accessory to have separate liability insurance for that system?
But like, can I take this a step further?
It's your court.
What, like for accessory, then would they also have to have entrances that have to be within a half mile of a connector road? And would they also have to have paved 16-foot roads through them? Right, we require a lot of things in here. I'm not saying that we don't need to carve out accessories. I'm just telling you, we've said if you have a campground.
The accessory use, what we have discussed, does not, like, it falls under the conditional use.
Conditional use within the A1
cup.
zone. Yeah.
It falls underneath the cup. If we don't say that in here to your liking, then let's say it.
My assumption, based on the chart that is in this document and the way I would interpret it and execute it, is that if somebody wanted that CUP and their road was less than 16 foot wide, I would recommend against the approval of that conditional use because of the inadequacy of infrastructure. By allowing it as accessory use on a 16-foot road, the assumption is that is the minimum standard that's created in doing that. And so, yes, we are going to hold accessory use RV campgrounds to development standards outlined in this unless otherwise exempted by this fiscal court. And so the idea is that these accessory campgrounds are not a free-for-all. They're a permit-reviewed use that just does not require a zone change, but will require adequate roads, adequate water, adequate sewer, and then now the question is, does it require additional adequate insurance? That is the question that I wanted answered by the fiscal court.
And I would propose that we do not require the insurance language for accessory use.
All right, to that end, what if I put a sentence on the end of that amendment? This requirement for liability insurance shall not be required for accessory use RV campgrounds so long as all WEDCO and development standards are met.
Yeah.
But what, I guess, but what if there is an issue on a smaller?
Homeowners insurance, we're talking about 5 or less RVs that are.
Right, pollution liability.
I mean, you would think that homeowners insurance would cover that. I mean, we can't what ifs and buts were candies and nuts, we'd all have a Merry Christmas. We cannot what if this and put in a sentence for every single situation. I think right now, if you flew a helicopter over Scott County and you looked at how many RVs that are out there at farms and different spots, they're out there. What we're trying to do is set a standard that can be implemented and protect the community. But the five, like, I am not, like, I do think that they need to be reviewed and go through that CUP process, and I am satisfied that that standard will protect those. But 99% of those accessory uses are going to take it to a dump station, or they have their own portable dump station, and we'll do that.
What's CUP stand for again?
Conditional use permit. And these are for like farms,
Mostly farms.
mostly 99% farms.
So should we carve out accessory use?
I like Cam's language.
Well, but like, I think there's other things in this that apply to it. Not just, like, I'm with you, but, right, like, I mean, it says in here that internal driveways must meet subdivision standards. It says for any campsite. It doesn't say for high density, low density. So by this ordinance, if you had an accessory use, if I had one on our farm today, I'd have to put in subdivision standard roads by the ordinance. So I'm saying maybe we should carve them out. I don't know what that looks like.
Yeah, I mean, if you have proposed amendments, go ahead and propose them.
Well, I don't know what all to propose. That's what I'm saying.
Spit it out.
I don't know what to spit out.
Like, we can't just
I'm
create,
trying.
you know,
I think what we want to do is embrace those situations that we pointed out that are happening now, where we have small groups of RVs that come from certain reasons, a horse event on the weekend or farming, and we're trying to make this where those are acceptable, but we're trying to gear the guidance to be for RV parks.
I'm 100% with you. I just don't. Now that Holden asked that question, when I start reading through with that lens, I don't think it allows for any of that. I wish you'd asked this question at that workshop last week. That would have been very helpful. I mean, I might be, maybe I'm reading it wrong, but that's the way that I'm reading it, right?
And if you want to make a proposed amendment that says that the general requirements of the ordinance do not apply to accessory use. Accessory use is only subject to the conditional use permit requirements. I mean, if that's what you'd like the court to consider, we can consider.
I'd like to hear Chad's thoughts. I mean,
we can consider these four, and then you can make an additional.
What are your thoughts, Chad?
Yeah, I mean, I think that's what the general, and Roy was there, and Dick was on that committee as well. But I think what we pointed out was these exceptions, and that we were trying to allow for these exceptions to take place, like what we referenced earlier. So maybe that only the accessory use should not have all the applications that for the majority of this ordinance. And
that's why we felt like the conditional use gave the flexibility, like in your case, maybe I've already got an existing one, I want to upgrade it to call it an RV park. The conditional use process might allow me to have a 16-foot road without shoulders. I just have to convince the fiscal court that in my case it's reasonable to do that. Here's why. I've had this situation for the last 15 years. Everything's fine. I would just like to now have it. I think we, as a committee, that's where my head was. Was that we had guardrails there called the CUP.
Roy Cornett, good to see you.
Ryan, to follow up, I'll give you two examples. Corner of 460 and Newtown Pike. There's a hunter jumper place there. It's on the southwest corner. Got an indoor arena. I've seen as many as 3 RVs parked there. People come in with their horses, working the horses in that RV, and they're parking there. Do they have a 16-foot driveway going in there? No. I'm sure they've got their sewer hookup tied into this on-site septic tank. Is there any problem with that? I don't think so. There's another one on Leesburg, Newtown Pike, just before you turn left on Coal Ridge Lane. There's another indoor arena there. I've seen 2 RV rigs parked there. sure it's the same situation. That place for sale right now. And do it require
Same
insurance?
same
and stuff?
situation on Crumball Road.
Yeah. And so they're, like you say, Judge, they're there. Do we need to require private insurance or 16-foot driveway? I just don't think so. But
So if you would like to, thank you, Roy, if you'd like to propose, like, just to have language that has the accessory use not, required to meet the standards of the rest of the ordinance, be happy to. Mr. Murphy.
Judge, just wanted to comment on the easement amendment. You all may not know that right now, the people who were talking to you last week and my clients are involved in litigation in Scott Circuit Court interpreting.
It doesn't surprise me to hear you say that.
Yeah, right. I'm not representing either party in that one because it predated when I was involved. But in that case, they are interpreting the language of the easements to say what use can be made of them and what cannot be made of them. That's what courts do. Courts apply to law and say, this easement can be used for this, or no, it can't be used for this. And that's going on right now. And I didn't know if you knew about that, but I'd ask you to take out the section about easements because you ask you not to step in the middle of circuit court litigation on that. Thanks.
Did you review, that's a fair request, I didn't mean to interrupt you. Did you watch that gentleman's comments on YouTube last week?
I didn't get to watch them last week. I think I heard them in a previous discussion.
Yeah, I just wondered if you had a thought on it. I guess what he stood there and said essentially was the existing language in the Planning Commission draft, you basically required consent from the servient properties. And this guy said, if you require that, lawyers like Dick Murphy, he name drops you, might argue that infringes on the property rights of the easement holders. So I guess in chewing on it, and we can take it out of there, that's fine, or not, but in chewing on it, the intent of that amended language was to try to protect the rights of the easement holders, but also acknowledge that if the, changed use changes the essential character of the easement, that in that case, it's fair to require consent. Do you have a thought on that, or?
Well, I think that's what courts do. I mean, if somebody proposes to use an easement which was designed for one thing for something else, everybody has recourse to the courts to say, no, that's not what it was intended for. And that's what's going on right now. And I just ask you to let that litigation go its course. The judge is going to apply the law to it and not jump in the middle of that.
I'll make a comment because I didn't know if we were ready to switch gears yet, but that's the question I had, and I agree with what you're saying, and I brought it up last week, that easements get sold with properties. We could be 2 or 3 property owners down the line from the original easement and what the original intent was, and I think we'd have a really hard time putting it in language in this saying that nobody ever was going to have an RV park is one of the reasons why they had granted an easement, just for this instance. But it could go for anything. So I agree. I don't particularly like that, and I think that especially if it's a 15-foot easement, it's not really that big, and it's just, and you've owned this farm, and it's your right to develop, and you check all the boxes, except now you've got a landowner that's saying you can't do that. So I agree.
So I just want to be clear on what you're proposing is any of the language on easements, just take it out.
Yes.
Okay.
But what if that easement changes the complete, but like if I have a tobacco farm and there's an easement through it and you just come straight through my tobacco farm and I'm now losing money, or I have a horse farm.
But I think that's like he was saying, they can litigate that in court, because I think if we put this in here, we're saying that, what does it say? Introduces substantially different use or purpose than originally intended. I would say original intent was always to give somebody just access to get back to their property. It was never to have a small business. You could write this into a whole lot of ordinances and block a lot of businesses that people should be able to have, I think. So I would think that would just be a court issue.
Just 1 second, after he's done, I'll give you,
Yeah, courts, if a lot of old easements say, I have an easement over your property for the purpose of farm access. Or sometimes they say, I have an easement over your property just for any kind of access. And that's what the courts look at. They try to interpret what the original intent was and grant the rights that should be granted and not grant the rights that shouldn't be granted. And this is in litigation, and that's where the system resolves these things, in court, in front of a judge.
thank you.
So
There it is. I think
I have to say, I'm
If you would share your name again.
Gerald Eichhorn. I'm really disappointed, actually, because I asked the lawyer with you to actually amend the language that we do not have the problems that you mentioned and I mentioned too. And I think this is extremely disappointing for me because of Mr. Murphy, because he points out that the Commission should have the discretion to evaluate all of the facts and make a decision. That is something that he always brings up, basically like a treadmill. And this is exactly what the amendment of this passes now does. It gives the Commission not only the authority, but the discretion to look at this and determine, does this actually change the intent and that was contemplated when the easement was given. If the Commission does not think they can do it by themselves, they can actually get an independent professional to do that. And this is where Mr. Murphy is completely wrong. The court is deciding conflict through the law, but ordinances are supposed to give us a framework that prevent litigation, not further it. Because he knows well enough that there's a lot of people, especially small farmers, that would not be able to compete in legal court with somebody that can go to the Supreme Court and back again, do this 3 times and spend $500,000 on a lawsuit that in the end is not winnable.
So just to make sure I'm clear.
Yeah.
The language that is in the amendment.
Right.
You oppose that, or
No.
you support that?
I think that the language is now very clear on the fact that if there is already an agreement, all of that is not necessary. But if there is disagreement, that the Commission can make that determination. So it is the discretion of the Commission, not of the subservient, the owner of the subservient estate, like you somehow implied. And it's also not at the discretion of the property owner that bought the land. So at this point, you have a balance between the property owner, the subservient estate, that does not conflict with the property law. He was right. Mr. Murphy was completely right. If you ban anything, and you were right too, and that's why I'm so disappointed, because I see you opposing something that you should applaud. You know, this amendment does exactly what you wish for. You get the discretion of the Commission that you basically bring up every single time, and now you don't want it. Now you want the courts.
So, Mr. Eichhorn, I would ask you to address the court.
Yes.
And
I support it.
You would request that the court leave the amendment as spelled out.
Absolutely, and for the same reasons that Mr. Murphy brought up all the time. For the discretion of the Commission, for your reasons, that is basically balance the property rights with the owner's rights, and I think you did well. Thank you.
Thank you.
I'm just going to make a follow-up comment, because when I read this, it kind of goes back to what the attorney, Mr. Murphy, was saying at his beginning when he was talking. I read this to be like there's almost no way for this to work if somebody asks. I don't think that,
You don't think that the Commission has any discretion to say...
Mr. Eichhorn.
Sorry.
Thank you.
It just says it's substantially different use or purpose than originally intended. And I think you can put that argument on every single request that anybody ever has. Like if they have a small business that they want to start in their property, and the owner of the property is going to say no because this wasn't the original intent.
But that's not.
But they may not even be able to build a house or have a home because this person, and then I know this is specific to RVs, but what's the can of worms we're opening when we start saying we're going to allow the people that have these properties that have a right of way through them, like what's their rights and what's the right of the people that paid the money for the land, that when they bought it in good faith that was going to be their property and they could do things that they wanted. So we can agree to disagree, but I don't like the language.
No, I understand.
And Kelly, I agree with you too. When you buy that piece of property and there's an easement through it, you buy that easement too. That's the way I look at
That's
it.
the way I see it.
So,
Unless it's agreed on when you buy it, like, hey, this is just for 3 months
in
a
writing.
year and it's
yes.
restricted easement.
Yeah, a restricted easement, we can always set those boundaries, but
But you don't understand, you don't.
Mr.
understand
Eichhorn.
that- Sorry.
No, I agree. And I know that there's special cases, and I think that's where they go to court and discuss those special cases. But I don't like putting a blanket statement out there that gives a right to say no to every single person that may apply.
There is no right to such in that ordinance. That's why it was amended. That's
Judge-
why I wanted it amended.
Judge,
Mr. Eichhorn.
Judge, if it's okay, what I would suggest is we can vote on these amendments one at a time, or we can vote on them. We can vote on it together. And
All right.
I
So
think
let's
that's
go.
right.
I agree with that. So I want to go back to Ryan. Do you want to make an amendment?
Let me just say, I am fine with this ordinance as the way it stands. I'm just saying the way that I read this. Well, yeah, sure. I'll make a motion. I know we have to do the amendments. I'm just saying, when Holden asked that question, it got my brain thinking that,
Thanks, Holden.
yeah, it's Holden's fault. Why didn't you bring this up last Friday I can't help that. But, so the way that I read this, though, so I have no issues with this. I'm not putting an RV park anywhere, so it doesn't affect me. But the way that I read this is that an accessory use RV park will have to have a sewer, will have to have insurance, will have to have roads up to a subdivision standard, so on and so forth. I don't know what the fix is. I can't think off the top of my head what the unintended consequences are right now of carving them out. I'm not saying we don't need to. That's just, when he said that and you start reading it, that's the way that it reads.
Sure.
So I'm fine with ordinance. I'm also fine if we carve them out. I just don't know. I don't know if we need more thought on what the unintended consequences are of carving them out. I don't know what those are. So
I think a sentence, because you brought this up, and I'll say it, I think we've talked about it with Mr. Murphy. Like, once the toothpaste is out of the tube, you can't put it back in. Once you know something, you can't unknow it. You have brought up your concern that the accessory use is subject to all the other requirements of the ordinance. So a simple sentence saying accessory use campgrounds are only subject to the CUP requirements of the Georgetown Scott County Planning Commission.
can I ask the Planning Commission if they have if they can think of any unintended consequences of doing that we're not thinking of?
Yes, please. So my number one concern with a total carve-out of requirements for accessory is that would then invalidate that chart or matrix that we created that says 2 units per 5 acres, 5-acre minimum, 16-foot road required. So at the heart of it, those would be the things that are most important, is making sure that it still is limited to 5 total, 2 per 5 acres, and it still has that 16-foot road. Past that and before that, there are a number of general requirements associated with all RV campgrounds, including 3,000 square feet per RV space, RV campgrounds no greater than 50 feet or no less than 50 feet from property lines, or in case it's U.S. right, 100 feet from right-of-way. Those are the things that I think are most important to protect, even for accessory uses. We should make sure that the accessory use RV sites are still away from property lines. Maybe there's still some landscaping required. There's still that 16-foot road. Past that, it was staff's intention to hold them to those standards.
So that would all be in the conditional use permit requirement.
From staff's perspective, yes, we would require all of those things. But it's much easier to make sure that we hold them to it if those are enumerated as opposed to full discretion of the Board of Adjustment. That would be my one concern.
You could also, just as discussion, draft it, like you said, accessory uses aren't subject to this ordinance. Instead of that, you could carve out what's exempt, like they're not subject to the insurance requirements you all think it said. Like what else? You want to list the things.
The sewer requirement.
Requirements.
So can I ask a question about theoretical?
Mr. Murphy? Yes, sir.
So let's say that I want to use the accessory use, and I come before planning and zoning, and I say I've got this need for an RV park. I don't plan to put in a new sewer system, but it's compliant with WEDCO, just as an example, and I choose not to take insurance out. You're going to say no, because that's out of compliance.
Yeah.
But the recourse is to come to the fiscal court and say, because you can say everything else lines up, but they don't have insurance. The court can always take an exception.
It wouldn't come to us. A conditional use permit.
Well, I'm sorry, that'd go to the
Board of Adjustment.
Board of Adjustment. But they would have recourse to, if they said, I don't want $2 million, I want $500,000 because I only got $5 million. I'm just asking, what's the reality that if you leave it unchanged, that I, as a potential small RV park owner, what option do I have? I think I have the option to come and say, I don't want to pay insurance.
Yeah, so the same Board of Adjustment that would review the conditional use permit also reviews variances. Typically, the types of variances, guys, thanks for coming to my seminar. Typically, the Board of Adjustment, the type of variances they review are related to dimensional variances. In this case, you'd be requesting a variance from a specific development regulation. The case you would have to make is that by sticking to that development regulation standard, it would create an undue burden or hardship on the applicant. Understanding the intent of fiscal court, staff could use that in our consideration. However, I'm very hesitant to utilize the Board of Adjustment in such a manner as to basically bake in a variance for a specific level of development. Because accessory or not, this still is a commercial undertaking which should be held to a certain standard. So is there recourse? Yes. Is that typically how our Board of Adjustment is utilized? No. I would be, again, there are certain development regulations that the Board of Adjustment can address, certain ones they cannot. In particular, like for instance, the Board of Adjustment can't vary density. Other than that, and Cam, I'm looking for you on help for this. Something like that insurance requirement would be underneath the purview of the Board of Adjustment. It would still just be the applicant's burden to prove that hardship. Am I nailing my case law on that one?
Case law.
Maybe.
It would be, obviously it's going to be up to you guys how you want this to read. But if what I'm hearing from this discussion is like, we don't ever want this insurance provision to apply to accessory uses, we should probably write that into the ordinance, right? You shouldn't have to have to appeal to the Board of Adjustments every time if that's the intent of the court is to not want that to apply. And if there's other things you don't want to apply, that should be written in too. That's why I suggested sewer or whatever else you all want. Makes sense?
Yeah.
If those are the two things, that's how it can be written.
That's the two things that.
Figure out a way to word that later.
Well, also like the roadways and stuff too, right?
So there's a difference between internal roadways and access roadways. So for the internal roadways, yes, we have road dimension requirements associated with that. That's a value call on you guys' part. Again, from planning's perspective, if this is a commercial undertaking, we would like those roads, interior navigational roads, to be up to our standards. For nothing else, consistency for development.
Just for accessory use.
Yeah, I mean.
So you want paved internal roads even for an accessory use?
If we're trying to mitigate offsite impacts, yes. But again, that's a policy call. where that could very easily, again, be, one of the things that's exempted out.
Sure, we'll get you back up here. Yeah.
The accessory use, am I correct that we're talking about a maximum of 5 RVs?
Yes.
And making a requirement for paved internal roads, I think, is an undue burden, and it doesn't meet really what we've talked about. I mean, we're talking about pulling an RV next to a show ring and not prohibiting that, having something on. I mean, I just really think it's we're throwing the baby out with the bathwater, and I would not support requiring. I do not support requiring for the accessory use. I do not support the insurance requirement. I do not support the because we're putting undue burden on what's already being used. I don't support the paved internal roadway requirement, and I don't support the specific sewers language that we have. We're talking about 5 or less, and we're talking about that most likely is going to be used at a farm. And I think that's what we all thought. We just didn't specifically enumerate that or spell it out in the language. And we spent 2 hours last Friday trying to trudge through this, and that's what I had hoped, that we would navigate most of those concerns last Friday. So we've had 4 amendments recommended by Dr. Wallace. I do believe we need to consider those individually, and then I don't want to go on without some type of language that addresses the conditional use accessory use and the insurance, the sewer internal roadways.
I brought this up before about the entrances.
It's in there.
Yeah, it's still saying that you have to have 2 entrances for 100 lots, campsites. But in our housing, you can build 200 houses with 1 entrance. So I don't know why we're requiring to have 2 entrances for 100 campsites when we only require 1 entrance for 200 houses. I've said this all along, it's still there. And
Well, Rob, I sent that to you, and like, I thought it was addressing what you were talking
I
about.
thought what you showed me the other day showed it, but it's not. It's still, what's in this says, what, it's on page 9, number 3. Campgrounds with more than 100 RV sites shall have 2 public entrances. And I just looked up Whispering Hills, and they've got well over 100 and only has 1 entrance. They've got far more than 100.
230.
Thank you, Mr. Murphy.
There's not one on the backside, the entrance-wise, didn't connect
I
up to
didn't
that?
see it on Google Earth. I just looked on Google Earth. I didn't see but 1 entrance.
Don't think so.
No, I've driven through there before. I think it just has one.
I think you're right.
Maybe I thought-
So I don't know why we're going to make somebody, because I'm thinking of some of the, and I don't want to get fixated on just this one property that has been trying to do. I want to think about the whole county, and I'm thinking about Sadie'ville area. There's areas up there that the road frontage may not be there to put another entrance in, but yet they'd have room to put the lots. So that's what I'm thinking of. And I've asked this and asked this and asked this, and it stayed the same, so.
Then,
Well,
then here, number 3, or number 2.
What's it say?
Is it, you're
But
saying
that's
it's-
secondary accesses. It's not
oh,
stop.
you're talking about primary exit?
Yeah. And then you get up to 600, and then you finally put in a third one. So numbers there just doesn't match up to me. I would think one for every 200 would be what you would need instead of, that's just, to me.
I mean, the only drawback I think to that is what happens if RVs start getting stacked up on the roads? I think that might be the reason why.
I don't know. I haven't heard any complaints out there on Rogers Gap.
Right, and I'm just saying that, I don't.
Of course, you
I
look
don't-
at theirs, their check-in building sits way back off the road too, and that allows them to pull in too and stack up inside and not just on the road. So, I mean, there's ways to avoid that.
I'm not opposed to personally to making it 200, to where you have one entrance for
I mean,
200.
to me, it just makes sense. I don't-
But then we need a secondary access point.
Well, secondary, they can put in as many, the way it reads, they can put in as many secondary access points as they want.
Yeah, you're talking about a primary
Yeah.
access
You know,
point.
for emergency vehicles, whatever. But just your primary, I don't understand why we're making them put two for 100 lots. I would think one every 200, and that's the way it should read to me.
Rhett, is that something that we, in all our discussions, on page 9, is there a reason why that there was 100 RV sites for where there's 2 public road connections?
You know where we are, sir. It says RV campgrounds with more than 100 RV sites shall have 2
Page
public
9.
road connections or access.
Yes. I don't, Elise has the exact numbers on her pad, but essentially it was loosely based around our requirements for multifamily developments. Elise, is that essentially correct?
Yes, the subdivision and development regulations list that single-family unit or projects with 200 units need the 2 access points, and multifamily need the 100
Once they get to
access points.
200 units, they can have up to 199
They could have a
before they have to put in a second.
for single-family
second entrance.
exclusive activity.
Yeah.
So I would propose, Mr. Jones, if you want to make a proposed amendment, we can vote on that singularly as well.
Yeah.
And that's what I suggest,
So one primary
for 200,
for 200,
or 199. Once you're 200 hits, you gotta,
you got to go to
Gotta
a
do
primary
the
and a secondary.
no, primary, you have 2 primaries.
to deal with?
Oh, okay.
You're gonna have What are you proposing, Rob? So
So
look out
up
the reads
to,
now and tell me what you want to change.
so one entrance up to 199 lots. At the 200th lot, you have to put in a second primary entrance.
So you want to change that with more than 200 instead of 100,
Yes.
okay?
It would be 200 or more.
Yeah, 200 or more.
And then,
And then on down
Next.
there, it says once it gets to 600, you have to put in the third, so,
the next
which is,
section below that says secondary access points may be constructed for emergency use only for RV campgrounds with between 100 and 199 RV sites. You want to keep that?
Well, that says may.
yeah.
That's
So you're
not-
good with that?
Yeah, I mean, that's just like a secondary. It's not gonna be your primary entrance. It's,
But it's also not a requirement.
And they shall be
It says
constructed.
You may construct it.
So you don't, okay, that's fine. So the only thing you propose to change is change it from the 100 to 200.
yes.
Okay, got you.
So I still go back to the language about how to address the concern about requirement of insurance, sewer, and internal roads for accessory use.
Yeah, I mean, Joe Pat could craft the exact maybe more precise language, but something like accessory use RV campgrounds are not subject to the insurance requirements, paved internal roadway requirements, or specific sewer requirements under this ordinance. Something like that.
Subject to the conditions of the conditional use permit process.
Okay.
Does that sound good to you, Holden?
Just to clarify that the accessory use would still meet the WEDCO standards for,
But if we put that language in there, then it would.
I would, okay, just,
I mean, I'm asking.
I can explicitly say that.
Yeah.
I would explicitly appreciate that.
All right.
Yeah, shall meet WEDCO and anything else?
Yeah.
WEDCO and other developmental standards.
speak now, or forever hold your peace. Does anyone else?
I will tweak this language and probably email it to you like after this meeting so you can give me feedback on that prior to the next.
But does anybody have any other proposed amendment? So,
That page, what I just said is not on there, so.
No, from 200, 100 to
Oh, I'm sorry.
Page 9.
Page 9.
Mr. Pratt,
Yeah.
you raised your hand, I thought.
Well, are we still good with the first reading? Are we, like, we can still,
Yeah, so we had the first reading, and then under the law. the
these are
court
just
is
amendments?
Permitted to make amendments to an ordinance after the
That's right.
first reading.
Perfect.
So we had the first reading, so.
I don't know what order
Several
you want to do them
amendments
in.
folks.
So if those amendments that are probably gonna be offered, if they pass, then
They'll be part of the second reading.
oh,
So we'll have a second reading, which will include those amendments, assuming they pass.
But we're going to vote on each individual amendment right now.
Correct.
Cam, can you read, if I make the motion
can, yeah.
for the amendment, can you read it, or do I need to read the amendment?
I can read it. if you
Okay,
like.
I'll make the motion for the amendment of,
The conditional use permit.
read it, Cam.
Accessory.
All right, well, I think you're talking, the one that,
Accessory use.
okay. So here's a proposed amendment. Accessory use RV campgrounds are not subject to the insurance requirements, paved internal roadway requirements, or specific sewer requirements under this ordinance, and are subject to the conditional use permit process. Accessory use RV campgrounds shall meet WEDCO and other developmental standards.
And a motion on your part?
That's a motion on my part.
Is that one of these amendments?
Yes.
He's going to have this.
And I will
No,
give the
that's
language.
not.
Right here.
It's not on here
No,
right
he's
now.
going to handle all of it. So there's a motion.
I'll second.
There's a second from Dwayne. Any other question or comment?
Oh, you don't. I don't know, I'm a little confused. I'm just, there's been so much talked about, I don't know.
So-
I'm still looking for the.
That's not in there.
It's not in there.
It was
So
orally brought up.
I don't
at
feel
this discussion.
comfortable voting on something that's not in there. That's just my opinion.
So, Rob, like, maybe this will help, because we talked about this at the last meeting. So the way that the process works is that Cam had the first reading, and then the law for this allows us to make amendments. So the amendment doesn't even have to be in
After
here.
the next reading, you can't make the.
Yes. So you can add any amendments you want to right now. They just have to be voted on.
Yeah, I mean, my hope was to try to get these in writing prior to today. That obviously didn't happen with all of these, that one specifically, but we're doing the best we can.
But here's the bottom line, though. There's been an amendment, there's been a motion, and there's been a second.
Just vote however you feel.
And would you like Cam to read that one more time, Mr. Jones?
Yeah, but it's not gonna change my mind.
Okay.
Then don't read it.
All right.
So we've had a motion, we had a second on the proposed amendment. Let's do a roll call vote, please.
just so I'm clear, we're talking about the one he just read.
Only one.
And it's for the,
Accessory use carve out.
yeah, and that's off that chart.
I'm calling this amendment number 1.
Okay.
Yes.
Okay. Mr. Hostetler?
Yes.
Mr. Jones? Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes.
All right, Judge, I'll offer another amendment, if that's permissible.
Yes, sir.
On
Mr.
page
Wallace.
5, under 2.514, where it's in red, for purposes of this section, that the language be changed from predominant to prevalent, which means widespread or commonly existing.
And then-
That would be my motion.
That also, I just wanted to point out, and Mr. Murphy, I think, pointed out, that predominant is used one other time, and it would be changed to prevalent the other time,
Yeah,
both times, on page 6 as well.
so that it would match what's
Yeah.
in the
Same.
comprehensive plan.
Page 5 and 6?
Yes, ma'am.
So we have a motion, we have a second from Kelly Corman. Any other questions or comments? Roll call vote, please.
Mr. Hostetler?
Yes.
Mr. Jones? Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes. Anyone else want to make another amendment?
Judge, I'll I'll apply, it's on page 8, that is the language about the insurance, that the original.
Under 6?
Yeah, under 6, that it read that way. I don't think we've made any changes to that, have we?
I don't think so. We considered a little change, but I think that's taken care of by the amendment you all just approved. With
Okay.
respect to Joe Pat's, the accessory use.
Yeah. That's my motion, Judge, to approve the language that's there in section 6.
In red.
Yeah, in red.
All right. Would there be a second?
Second.
Second from Ryan Pratt. Any other questions or comments?
Yeah.
Roll call vote, please.
Mr. Hostetler?
Yes.
Mr. Jones? Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes.
All right, this is, I guess the next one, Judge, is one that's, we have a question, and I guess before I make a motion, Cam, on the easements, currently, if there is some type of contest to this in court, the judges would be they will be basing their decisions off of state law that has to do with easements, is that correct?
Yeah, state and common law.
Okay, so this ordinance is if this section is allowed, does that now change the course of the contest in circuit court, or are they going to still base it on state law and common law?
Assume, and Mr. Murphy, y'all tell me if you disagree, but it could go to court either way.
Anybody can
Yeah.
take it to court.
You see what I'm saying? Is this going to change the course of that
I think
lawsuit?
the intent of drafting this language was in response to the discussion last week in attempting to balance the property rights of the easement holder versus the servient property. We've had a bunch of discussion today, so I don't know if that changes anything. I've sort of heard 2 amendments proposed. One is the one that's drafted. The other is just take the whole thing out, which I think you're probably going to propose that.
Mm-hmm.
So you've
And we also need to be noted that there was language that was submitted from planning and zoning that had to do with this.
requiring consent.
Yeah.
I think what I'm hearing from Elise, you tell me, I don't want to speak for it.
Oh, no,
You'd like to take that out, is what I'm hearing from.
No, I'd like to take that out,
Yeah.
because I don't think it should be on the owner of that property to have to go to court and now get a
So-
lawsuit to try to sue somebody so they can do something on their property.
So is that your motion?
I think Rob and I agreed that, like, when you buy that property with that easement, unless it specifically says that you're restricted, then I feel like you should have that right to use it just like it would be your property.
So
Well, let me,
Go ahead.
We don't have to take it
hold
out.
up. That's what I was going to say. Like, unless somebody makes a motion to include that amendment, then it's not in the language of the.
Yeah, but he doesn't like how it's currently written, even as coming from them, I think, is what right?
I'm saying.
You don't like the sentence, these connections cannot be made to easements traversing through adjacent property without the written consent of impacted property owners.
Yeah.
You want to take that out? No? You don't want to have, that's what I heard you say.
Well-
I don't speak for you.
No, I was really hung up on all the new stuff that was in the red, but you're right. I mean, it's.
Well, I don't want to speak for you. If you just don't like the red stuff, that's fine. I'm just trying to understand what you were saying.
Well, I think about this, that last sentence basically says in black is what you're also against, Kelly.
That's what I heard.
No, you're right. You're right. It says without written consent of impacted property owner. You're right. I don't like that.
Let me ask you this. Is this, this ordinance only pertains to RV campgrounds?
Right.
Yeah.
And
But if you've bought property and now it checks all these boxes that you're on big enough road, all the things, except you've got a 20-foot easement into your property that you bought 20 years ago, now you got to go get written permission from the.
When it comes to RV, though.
I know, but what if you want to open an RV? That's legitimate business. Right, right. And I mean, if it meets all the boxes, I don't, unless that is some sort of restrictive easement, then I would be against that.
All right, Judge, let's play the cards here.
Yeah, I'm just one vote.
Yeah, I'd say vote it up or down. That's kind of how I feel. I'll make a motion that on page 8, subsection E, that we include the proposed language that has to do with easements through property that's in the red.
Just like this.
Just what I read.
Yeah, whatever.
Black and red, or
Yeah.
just the black?
The red.
Yeah, just the red.
Just the red.
No, black and red.
Yeah.
Cam, this.
Yeah, I threw it right here.
See that, please?
Yeah.
Yes.
There's been a motion. Is there a second?
I'll second to do the vote.
So we have a motion, we have a second. Is there any other questions or comments? Roll call, please.
Mr. Hostetler?
No.
Mr. Jones?
No.
Mr. Wallace?
Yes.
Mr. Corman?
No.
Mr. Ellison?
I'm going to say no.
Mr. Pratt? No. Judge Covington?
I would qualify my vote that I still have great concerns about, I understand everybody's no vote, but I still have concerns. This is only to an RV park, and I do not want to ever trample on private property rights either way. So, it's not going to carry, so it's a dead issue, but I'll vote no as well. But it's still a major issue to me about the whole issue.
Black state, though, Joe.
Yeah.
Well, I know, but I'm about to make the motion.
Chad's got one more, I think.
Yeah.
Chad's got one more.
Yeah. And on page 10, it would be to not allow low-density developments on 16 to 18-foot wide roads, that one area would be permitted out of allowed RV parks on that's width of roads. That's my motion. Yeah, that's it.
So we have a motion. Any questions about that motion, and would there be a second? So there's a second. Any other questions or comments? Roll call vote.
Mr. Hostetler?
Yes.
Mr. Jones?
Yes.
Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes. Would there be any other amendments proposed?
So I'll make one last request for an amendment, just because I don't think it's, and I've said this, don't keep repeating myself, but I don't think a property owner should have to get written consent from somebody they've bought property from that granted them an access. So I would make a motion to strike on page 8, letter E, I.
So we have a motion.
What was it, Kelly?
Yeah, to strike all
Just
this.
strike all of it?
Yeah.
Okay.
So Kelly, what would you say, can I ask this question real quick? So if I had land and I sold it to a child of
Makes
mine,
sense. Go ahead and make it.
50 acres on the back of my property, and I gave them an easement to build a house, and then somebody bought it and wanted to put an RV park. You're saying that when I gave the intent to them for my son to build, or my child to get to their house, and now somebody else put an RV park on it,
This is why it goes to court, because when your child sold it to those people, did they say this is restricted only to a house? Or if they want to open a small agricultural business and sell landscaping supplies, or open an RV park, or?
But we're not, that's not, it's only RV campground.
Can I ask you a question about your motion? Do you want to strike the whole thing or just the second sentence?
Well, the first part of it's already what we just passed.
Okay.
It's okay, right?
Yeah,
You want to strike the second?
Second sentence.
You said the whole, okay.
I'm
Just to
sorry.
make sure.
No, I'm good
Really
with
don't need
the,
All right.
yeah.
But the first part we just passed on the other amendment Chad had, so we really don't need that first part. right? Because we just passed, you can't have a, well, I guess, no, not really.
I don't think. I think what's on the what you're proposing is to take out the requirement for the consent. Second sentence.
Right, the consent and then what's in red, which was what we voted down.
That already is out.
Yeah.
Yeah, but what about 1 and 2 under I there? I think you want to leave that probably.
Yeah, I would think that you'd want that.
He's just taking
I think
out
he
one
just wants to
sentence
take that one
Yeah,
sentence
I'm
out.
taking out the asking,
These connections can,
Oh, okay.
is your amendment, these connections cannot be made to easements transversing through adjacent properties without written consent of impacted property owners?
Yes.
Is that what you want to strike?
that's all I want to strike.
Second.
So there's a motion and there's a second. Any other questions or comments? Mr. Murphy, yes, sir.
So, Kelly, I guess this is to you. You're okay with one business putting another business out of business?
No, I've never said that.
That could be essentially what you're just doing.
No, no way at all.
Well, no, if you've got an
It's a free
existing.
market and people can open businesses and people have properties.
No, I
and
understand.
do small businesses all the time.
But if I've got a horse farm, which I do,
Okay.
I don't have an easement, so I don't really have a dog in the fight, as Cornette
Sure,
would
I
probably
don't
say.
either.
But you can do substantial damage to enforcing an easement through my property if I'm now suddenly forced to put gas line through, power line through, water line, and a
And if
roadway.
you told the people buying the property that you gave an easement to that you can't do these things, and it's written up, I understand. But as a property owner, I think you have a right and an understanding that, like, when I buy this property, we have this American right, like, I can do what I want to, and if I can check the boxes and have a small business and compete with somebody down the road, that's perfectly legal.
But if it's an easement that goes back 150 years, none of those things that I just mentioned were anticipated then.
Well, sure, they've never have been. There weren't even a lot of cars in those areas.
Right, but I'm a small
So can you
horse
say
business.
that you don't want to have a car go across it because that was never the original intent?
I think that's transport, so that probably would be covered. But my point is, without some regard to easement restraint, and I was here when, at that time, it was Mr. Perkins, Charlie Perkins, was also in agreement that it's not reasonable to impose on one business a hardship that's going to put them out of business just to pleasure someone else's business. That's all I have to say on it, because that very well could happen. And in the case that's the elephant in the room here, that's probably what would happen.
And I don't know what the elephant in the room is. I'm just speaking on behalf of people that I feel like have bought property and have a right to do the things that everybody else can do with their property.
But, just one second, please. But I'll go back to saying that this ordinance is only speaking to the development, and that language is only to the development of an RV park. That's, and I just, and no
I go
matter.
back to a little bit of,
No matter.
everybody has rights until their rights infringe on others.
Yeah.
So you have to always balance it.
Yeah.
So just saying.
No, and I'm.
You're saying it's specifically RVs are more of a hindrance than any other
No, I'm
business.
not. I'm not.
That's why I'm saying I
I
don't
would-
split the hairs and decide what's allowed and what's not.
In the best case scenario, a business owner would try to play nice and work with whoever they are
Sure.
moving into, and you do that ahead of time. But
Right.
we don't have the option or the luxury to hope that that's going to happen. So we got to put some guardrails up for people that don't, who might have a sensitive area that a development could come in on top of them based on something
And I
unforeseen for everybody.
And I understand that and respect it.
And-
I just know that it's hard for me to choose who the winners and losers are.
Yeah.
And no matter what, if the owner where the easement is owner of the property where the easement is located doesn't like what is proposed, they're going to go to court no matter what.
Sure.
And it doesn't matter if we have that language in here or not. But I think our efforts were trying to be responsive to a concern that was brought to us, and that was how that language got there. And it's a two-way.
Completely understand and respect that.
Yeah. So there's been a motion.
Rob made a second.
And Rob made a second. Any other question or comment? Mr. Icorn, you wanted, all right. Roll call, please.
Mr. Hostetler?
Yes.
Mr. Jones?
Yes.
Mr. Wallace?
No.
Mr. Corman?
Yes.
Mr. Ellison?
No.
Mr. Pratt?
No.
Judge Covington?
No.
Who said yes?
Rick, Rob, Kelly. Yeah.
So what was the count on that? So
Three.
it's staying in.
4-3.
Yeah, so the black lamp was easy.
You want to make that motion?
Yeah.
Uh-huh.
And then you wanted to do the 200. You can do that now.
Number 7 is 200.
All right. Go ahead, Rob.
So on the entrances, if we can change that to read 2 entrances once it reaches 200. So you're allowed 1 entrance up to 199. Once you hit that 200, you have to put in a second entrance. Am I saying that right?
Yes, sir. Makes sense.
I'll second that.
Any other questions or comments?
Well,
Rob, you're not changing the other stuff that's down there?
right.
It didn't apply. Yeah, so.
Okay, so then, well, number 2 talks about the secondary access points.
But that's a secondary. You can put in as many secondaries as you want.
Don't think second, think secondary.
Yeah.
Well, okay, hold on a second. It's, those shall be constructed. Now they use the word, it uses the word shall. So this other entrance, you see what I'm saying?
Oh, I get what Rob's saying, or what Rick's saying.
That's 3
So-
entrances
But
now.
a secondary entrance is not your primary entrance.
Well,
Once you reach the 200, you have to put in that second entrance, but you also have to put in a secondary.
so you have to put in 3 once you get to 200.
Wind up with
Is
3.
is that right?
Yeah.
Am I thinking right?
I'm not going to say wrong, but that wouldn't be how staff would
Hey,
interpret
I'm
it.
not embarrassed if you tell me I'm wrong.
The idea is if you've moved it to 200 RV sites, which requires 2 road connections, the point of that 2 underneath there was when there was this 100, then there's all this gap, 190 or 199, and then there's 200. For that middle section, 100 and 199, there could be a secondary access point, but it didn't need to be open full time. It could be just like an emergency access.
Yeah.
My reading with what the language proposed would be is when you get to 200, you have to have 2 access points, and both of them have to be open full time.
Yes.
And so that would be the intention from staff's perspective,
Yeah.
2 full-time permanently open
Once you
entrances
got to
at 200.
Yeah.
Yeah.
But then you wouldn't,
So should we?
But you would have,
Between 100 and 199, you could still have and that's why it says may,
right.
for that number 1 there. You could
But-
still have a secondary access
You have
point.
primary and then an ambulance fire
Yeah.
type of road.
but number,
only.
But then when you get to 200, they're both open all the time.
That's where I'm at. That's where I'm thinking.
right, but your proposal is making it mandatory to have the 2 entrances open. But then
At
number.
200.
At 200.
And so.
But it says that on
Number
number
2
2.
says secondary access points shall be constructed for full-time public use more than 200. So that would mean, I'm not an attorney, y'all know that, but that would tell me that now you gotta have 3 access. 2 road and you gotta add an access point. I'm just saying, it seems to me like that probably needs to go away.
So the number at the top line should read 199. Once you read 200, it's already in number 2, saying you got to put in a secondary at 200. So
That's secondary access, yeah.
does that make sense? Right, Cam? Put it at 199.
Phone call. What'd you say, sir?
Should be
It
at
should say
199.
RV campgrounds with more than 199 RV sites shall have 1 or 2, no, 1 public access, public road connection at 199.
Instead,
The alternative at number 2 would just remove the word secondary and just says access points shall be constructed for full-time public use for RV campgrounds with more than 200 RV sites. And so get rid of secondary. I think that would address your concern of this primary secondary question.
Yes.
Okay.
Thank you.
It
Everybody
should
cool
still
now?
say 200 though.
Yeah.
Yeah. Got it.
So that's a motion. And did we have a second?
I'll second that.
And what's the motion?
Hold on, I have a first and a second. Rob and Dwayne.
Oh, okay. I'm sorry. I'll
Okay.
draw.
So
But he
RV
left,
campgrounds
so-
with more than
Yeah,
200
these-
RV sites shall, or it should be 199.
There he is, okay.
That should be 199.
We'll change from 100 to
Right, Cam?
200. Cam said no.
what's your motion, sir? Do you want it 200 or 199?
I think it needs to be 199 because come on down here when it access points in number 2, it tells you 200. You got to put in a second entrance.
Okay.
So it should read like this.
Well, they said if you mark out the word secondary, then 200 makes sense here.
Okay.
But it's whatever you wanted to.
Rob, can you restate your motion for
I
everybody?
still think it has
I'm
to be
confused
199.
again.
I still think you have to have 199, and this would be 200, I think. But that's me.
What do you think?
I think you're still right at 199, and then this has to be.
Because number
access.
2 tells you 200, you got to put in a second.
So I think that's what Holden's saying. Just take out the word secondary.
Yeah,
Right.
take out the word secondary. At
So then
200,
that allows it to be 200 at the
Yeah.
top.
If you wanted to be consistent, it should be 200 at the top and then do what Holden said on number 2. Otherwise, if you have exactly 200, you're going to be confused.
right.
Okay, fair enough.
Yeah, all right.
Mr. Hostetler?
Yes.
Mr. Jones?
Yes.
Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes. Are there any other amendments?
Judge, I'll make a motion for approval as to pass this first reading as amended.
Is there a second?
Oh, go Dwayne.
Second.
Second. Any other questions or comments?
Was that Ryan?
Dwayne.
No, Dwayne.
Or Dwayne.
Start down there this time.
Roll call.
Lead the way.
Mr. Hostetler?
Yes.
Mr. Jones?
I'm going to vote no because I'm still fuzzy on that one. I'm still not good with it.
Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Judge Covington?
Yes. We'll have this on the agenda and we'll send out a clean copy for all. And we'll have this on the agenda at our next meeting. Number 9.
Just a quick comment, real quick. Thank Mr. Murphy. Thank Chad. Those two right there.
Roy.
Judge, you have too. Y'all spent a lot of hours on this. I really appreciate y'all's time on it.
Thank you.
I've got to go, guys.
All right. EMS software agreement. This was shared by email. It's replacing an agreement that we could not really meet terms with the vendor to meet our needs. Any questions about this, and would there be a motion to approve?
Motion.
Motion. Second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Number 11, EMS staffing proposal. I've shared an email, and there's been several emails shared and a lot of data. And yes, ma'am.
EMS promotion.
Yeah.
I'm sorry, I skipped EMS promotion. All right, EMS promotion.
Yes, thank you. On behalf of Chief Roney, and I'm pleased to recommend the promotion of Madeline Williams for the captain position in EMS. That promotion will be effective November 22nd. Her new rate of pay will be $21.76 an hour. She's been with EMS since January of 2022 and was promoted to paramedic in July of 2022. She's been with us for several years, and she has over 6.5 years of experience in the field. She also has an associate's degree in paramedicine, so that's the recommendation for the court. I don't know if Chris, anything else he wants to share about Maddie's qualifications?
Any questions or comments?
Motion.
Motion. Second. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Now, the EMS staffing proposal. So, Chris, July we went to 6 trucks. Since then, we have it's been a challenge to keep 6 trucks on the road. And in an effort, looking at staffing, looking at unscheduled overtime, in an effort to reduce unscheduled overtime and try to give us the best scenario of keeping 6 trucks on the road, it's been recommended as a measure that would probably be, if it would probably be budget neutral and offset the unscheduled overtime that we're experiencing right now. It's still not going to be, I think, the magic wand because the truth is we're probably going to have to look more at our staffing as we go forward in the next budget year. But trying to be respectful of the current budget and just trying to get us to where we have 6 trucks on the road and more consistently and then not as much pressure on our staff as well. What's been recommended right now is placing or hiring 3 additional EMTs. Now, another piece of this scenario that's been shared that needs to be considered, but I don't feel comfortable today, I don't feel comfortable right now making a recommendation, but we do need to look at part-time pay rates for EMS, paramedic, and EMT, and we need to consider that in the future, I think, to help offset staffing concerns and then also to keep 6 trucks on the road. So this certainly would be a first step, and we could come back at a future meeting and share more data about part-time rates. You always get caught, or I always have the concern about, having consistency and you don't want, traditionally, I've always had concerns about is paying a part-time person a higher rate for the same job, the same work than the part-time. I might have said that backwards.
You mean full-time?
Yeah, full-time.
Yeah.
So, we have made great effort to really make sure that our benefits and those that are part of that package are, part of the compensation package. That has to be considered part of the compensation in my mind. But that's something we can revisit at a future meeting, probably sooner than later. But I think we need to look at that independently from this recommendation of what's before you today is hiring 3 EMTs. And that would be 1 per shift, and we'd go from there. Questions or comments?
I'll make a comment real quick because I've sat in some of the meetings and discussed this, and it's the shifts and the way that it works is kind of complicated sometimes, trying to figure out hours and overtime. But to make a long story short, because you guys didn't get to sit in those long meetings, but I support what Jeff has recommended with 3 people, and I think it makes sense. And obviously, we're going to continue to look in the future at how we staff and how we do things. But I just want to make that comment that I think there's been a lot put into this before we got here tonight.
Questions?
Maybe just a comment, because a lot's transpired, but the big change was when we brought the 6th.
In July, moving to the 6th truck.
Right, and because for the 3 or 4 previous years, we were staffing 11 folks, but even then, was that requiring, when we just had the 5 trucks for the previous 3 or 4 years with the 11 was we were still having unscheduled overtime.
And let me speak to that too. Like, what's been shared with me is one FTE really doesn't give us one. What we end up getting is closer to 0.9. And because of taking off, vacation, sick, and training too. So, Jeff, would you want to comment to that?
I mean, that's correct. When you take the 39 people that we have and you take it times the 0.9, because when you factor in vacation, sick leave, educational leave, maybe in a little bit of time that where people were filling positions or a workers' comp claim, you really only have 35 people when you take it times the 0.9, the 39 people times 0.9. So you end up with 35 people.
And that's
So you're
from
really
your
short.
calculations and assessment of the big picture of all the data.
Because we were trying to figure out, well, why are we short and why do we have this unscheduled overtime? Well, it's because we're expecting people to work 100% of the time. They just don't work 100% of the time. I mean, it's just not practical.
Let me ask you this question, because I really struggle with adding people and not in budget time.
Sure.
And I do feel a little bit better knowing that it's going to be offset by budget. I mean, the offset of overtime will be.
I mean, we're going to reduce the unscheduled overtime that's in that line for salaries and such.
I mean, I think there's even a chance for some savings, but at worst, it's going to be cost neutral.
Yeah, but should we not be looking at this in a different way? Should we not be looking at and try to bring more part-time people in and looking at increasing the pay of part-time first and then add the ENTs, or?
We still are going to have unscheduled overtime, even with adding 3 people.
Yeah.
So we're going to need to have also beef up the part-time ranks.
Okay.
We've just got to get to July 1st.
And the reason it's only 3 is in respect that we are mid-budget, but we're just, I mean, we're really, it's a challenge to keep 6 on the
bigger
road.
issue right now is that we have 6 ambulances on staff, and we need 14 people for those 6 ambulances. No, we need 12 for the 6, and we're short right now.
I understand.
When we added the 6th ambulance, we didn't increase staffing, which we should have done in this budget year.
I have 3 thoughts. One, I'm for the full-time. I think it'll help EMTs. 2, I think we have to look at our part-time pay, increasing it, because we're not paying retirement. We're not paying insurance. We're not paying like, there's ultimately a savings. Even though they're making more, we're still ultimately paying them less, right? We're not paying into their CRS and all this other.
Unless they come from another agency. If they're already working full-time for another agency and work part-time for us, then we do pay retirement.
But we don't pay benefits. But then I think we also, like Natalie sent some stuff, like we've got to like watch like one pay period. Some of this educational overtime stuff is out like 37 hours of unscheduled overtime just for education in one pay period.
And I've asked Chris to start charting and tracking the UOT in different categories of why. And I think we'll have that for you, and I agree with you.
Just want to comment on paying the part-timers higher. I know in Stamping Ground, when we were trying to hire a second police officer, that's what we had to do to attract somebody, because the full-time officer was putting in more hours, but the second officer, he wanted to make this much money, and that's the only way we could get anybody.
I think we're the same.
So any other questions? Mr. Hostetler.
One of the other things that was cruising through my brain is and we've had the discussions, it's been in the emails, the captains, there's one on each shift, right? And so, and I know they have other duties, but I also know, because you've told us that they step in and ride the ambulance.
Yes.
And still, especially since we added the 6th truck, which I think is a good move for our community. It's more money, but I think it's a good move for our community. But this will, as you've already said, this should maybe possibly be neutral on the cost, which would be great. But still, there are going to be times where the captains, even if we go with the 3, right?
Yes.
Where they're going to be called upon.
Oh, yes.
Or maybe other staff, right? I mean,
Yes,
because
And the thought process is because typically you're going to have somebody off on a shift, either vacation, sick, or they're injured, whatever. The thought process is then rather than to put that out as overtime, we just have the captain backfill the ambulance. And that's how we staffed the 6th truck, because we had a floater per shift for 5 trucks. So we just put the captain to make that 6th truck. But again, where you normally have people off, we rarely keep 6 on the road.
And are those shifts 24?
24-hour shifts.
Yeah, and then 2 days off, 48 off, and then, right. Okay, and which the captains are on that as well, right?
Yes.
Gotcha.
All right, anything else?
I make a motion for the,
Have a motion. Is there a second? Second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Thank you all.
Thank you.
Fire Department promotion, Jeff Mudrack.
Yes, I have one more piece of business here before you. That's on behalf of Chief Ward, I'm pleased to recommend the appointment of Jeremy Barnett, who is with us today in the fire department. His appointment will also be effective on November 22nd. The new rate of pay will be $25.57 an hour. Jeremy's been with us since October 1st of 2018. He was promoted to company officer in September of 22. Jeremy was the only candidate that holds a bachelor's degree in fire science. In addition to that, he holds 2 additional master's degrees. So without a doubt, Jeremy is a well-qualified candidate for this position. And I don't know, Chief Ward, if any other comments you want to share?
Yeah, Judge Magistrates, just on top of his time here, plus, the degrees that he holds, the one thing I can say about Jeremy is Jeremy always looks for what can he do to help the department and what can he do to help the members that are there. And for example, we recently, in discussions talked about we need to do something to prepare our people to step up into leadership roles. That was a conversation. Jeremy took it upon himself and basically wrote and created what is now our company officer development course. We just recently, I think last week or so, have put it on twice. So those are just the type of things that Jeremy does to help our members and help our department.
Any other questions or comments? Would there be a motion? Motion from Rick Hosteller, second from Kelly Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Mr. Barnett, would you stand? You're here with us. Thank you for your service. Thank you for what you do, and let's give Mr. Barnett a hand. I'm grateful to have you, and look forward to seeing what you do for us. Strand Agreement Amendment is the next item. I shared this. This is just some minor changes to the agreement with Strand for design services for the Legacy Trail extension. Are there any questions or comments related to that? And would there be a motion? Motion from Kelly, second from Rob Jones. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Thank you. Bid results for the courthouse HVAC. I know Rick has talked to us, and Rick, would you like to step out at this time?
I would. I need to say that for the record. 2 reasons. The design team, Trout Tate Wilson, I'm currently on a project that they are the design team, and I work under them, so I'm accusing on that point. And the other point is Brent's Electrical Solutions is I think the low bidder here for the electrical, and he's my son. So accused on that as well.
Thank you, Rick. So with that said, we've discussed this, and I've shared the information. I believe it's in the best interest of the project to move forward with the low bid for the base bid of $999,000 from TP Mechanical. I believe the first alternate for the pumps is required and in the best interest of the project. And I also believe that while we're here doing the work, that the bid to improve the lighting in this room as that alternate for this room that was listed as well, I believe that's
alternate number 2.
Alternate number 2. I'd love to say I could support doing alternate 3 and 4, the tower lighting, internal and the external lighting. I just don't think it's, with the cost associated. I'd love to hear your all's thoughts on 3 and 4, or for that matter, on anything else.
I agree.
I'd like to see them.
Well, that's going to be separate.
Well, no, but
Yeah.
I'd like to see, they could give us bids, totally separate from this.
We'll get estimates.
Yeah, estimates for doing that.
Yeah.
If they're already here.
We'll purchase them, and then we'll just get estimates for somebody to install it. That's what I thought, but we do need to do it, and I'll share that information separately outside of that. So
I agree with your comments, Judge. I think it's well overdue for the HVAC to be repaired, the lighting in here to be done, so I think that motion.
So we have a motion. And now,
With 1 and 2?
Just the lighting in here and the.
base bid,
Base,
alternate 1 and alternate 2.
yes.
Second. Any other questions or comments? Now, we will use, because we budgeted $900,000, we will have to pull some reserve from transfer. But just to let you know, I saw a preliminary schedule, and they won't even get started on this work until I think February, and it'll stretch out till, like I saw, like ending in June sometime. So, like most likely we'll have to budget the tail end, and hopefully we won't have to pull any reserve. Yeah. We can put it in next year's budget.
Right.
And do that. So we have a motion, we have a second. All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Number 15, bid results, storm shelter. Mike's here. We had received.
Can you get Rick? Oh.
I'm sorry, glad you asked that. Can you pull that bid out? We had one bid, and as I shared last week, Safety Shelter, who previously bid, did not bid. We had one bid of $224,000 from Hinkle Construction Services. As I told you, I reached out to Lauren Rochella with Hinkle earlier in the week, and I asked, if the court did not elect, because we don't have the funds in the budget to cover this, we'd have to do reserve for transfer. I said, is there any opportunity for value engineering? And he said, yes. I have not received any of that documentation as of yet. So what I would make the motion of is to reject this bid and authorize Cam and I to do some competitive negotiation with Hinkle Construction and bring that back to the court.
Motion for approval.
Motion, second. Any other questions or comments?
Ryan, was that you?
No, it's Kelly. All those in favor, please say aye.
Aye.
Any opposed? Motion passes. And since this is a special meeting, we cannot have any other business, so would there be a motion to adjourn? Motion, second. All those in favor, please say aye. We are adjourned.
Oh, man. Like we've been in a football game.
Cam, you already know I'm gonna need help.
Yeah, no problem.